Thank you all for being here. I'm William, and this is Brad. And as Tiffany said, we are going to stick to schedule. So there's going to be no long-winded introduction or anything like that. We're just going to get right into it. So today we are talking to you about scheduling. But this isn't going to be a broad survey overview, 10,000 feet. Let's talk about what concurrent delay is and the 4 types of schedule delay analysis or anything like that. We're going to focus on several discrete issues through the lens of recent cases in Texas, or at least fairly recent cases in Texas. And so I think we all inherently know that scheduling is a fundamental component on just about every construction project. And as our little cartoon here shows, it is an inherently complicated aspect on any project, particularly the larger and more difficult your project becomes. And so what we want to focus on today are a couple of things that'll help you manage the mess that's over there on the right, that'll help you bridge the gap that's in the middle and get to that final miracle at the end. And we'll also talk about a couple things to do if and when you don't arrive at that miracle at the end. But again, we're just trying to focus on several discrete issues through the lens of recent cases. And so we're going to talk about several cases on notice requirements. And although those cases don't necessarily address construction schedules per se, the findings and holdings and facts of those cases are nonetheless incredibly informative for dealing with schedule delays, schedule impacts, damages, dollars, all of those things. So Brad's going to walk you through a couple of those cases today. We're going to talk about issues with causation. How do you tie a delay event to a delayed day? This is something that we see over and over and over again, that either project managers or later on forensic experts show up. They say, in one hand, I have a bucket of delay events, and in my other hand, I have a bucket of delayed days. But many times there is missing that critical causal link between the two. And so we're going to look at one specific case that isn't necessarily an example of how to do it, but rather a very stark example of how not to do it. So I'm going to walk you all through that, and then we're going to close with liquidated damages and a recent or fairly recent case coming out of Texas that provides some interesting context and nuance for considering and drafting and formulating and contemplating your liquidated damages clauses. I want to set the stage, though, for Brad before he gets into his notice cases by just covering a few points that I think will save Brad some time and will help set the stage for the cases that he's going to walk you through. And so, claims, whatever they may be, whether it's a formal capital C claim or just a little c claim, hey, I've been delayed on a project, almost universally require some form of notice. And so there's no bullet point up here because I know you all get it, but the very first thing you do is you look at your contract. Right? What does your contract say? And you never ever want to do less than what your contract says, if at all possible. But beyond that, there's some other things you want to keep in mind with notice. And within the scheduling context, one of the most important, I think, components, practical components of notice is informed consent of potential delays to the schedule. Because your schedule is a tool, but your tool is only as useful as it can be based on the information that's put into it and the information that's shared with the parties. So good notice practice helps maintain good informed consent so that all of the parties, whether you're a contractor, subcontractor, owner, can manage and address those schedule delays. And within that, and I don't like the F word, but I'm going to say it, within that there's an inherent sense of fundamental fairness. It allows you to assess implications and potential liability. It allows you the opportunity to investigate events, delays, damages, dollars. It allows you to document schedule impacts post-notice. So you can provide your initial notice, but then as a matter of good hygiene and housekeeping, you can continue sending those notices so that everybody remains informed, up to date, and in the best position possible to manage potential delays. And ultimately, good notice practice allows you to fairly adjust the contract, because I think at the end of the day, that is the ultimate goal. Again, whether you are an owner or a contractor, you want to account for the delays in the contract so that you avoid protracted litigation later on and you can manage and execute your project as appropriate. And again, just to set the stage for Brad, this is just a little housekeeping reminder that notice can take many forms. I mean, as always, look at your contract, see what's required. But beyond that, written notice can be schedule updates. It can be emails. It can be the serial writing campaign that I'm sure everyone has been engaged in at some point in time. It can be meeting minutes. It can really take any form of writing that's exchanged between the parties. And as you'll see in the cases that Brad discusses, what forms and formats those notices take impact your ability to not only notify other parties of delay events, but to also preserve your rights and claims, or on the other side, defeat those claims. So without further ado, I will hand it over to Brad, and he's going to walk you through a couple cases on notice.
Oh, thank you, William. I'm assuming y'all can hear me. Let me check this 1 second. Great, good. So first, notice is often the threshold issue to address when considering schedule-related claims. Entitlement to schedule relief or delay-related damages will often hinge on proper and timely notice. So what is this proper and timely notice? What is the compliance? What is necessary to provide the specifics behind the notice? As William said, let's look at your contract. So what does the contract provision notice, the notice provision in the contract look for in this matter? So this is a very recent case out of the Texas Supreme Court, James Construction versus Westlake. Now, the issue here in this case is not specifically schedule related. However, it does provide some color regarding and some guidance regarding the application of contractual notice requirements and the obligations of the parties required to provide notice. So here the issue was the owner's entitlement to recover contract damages associated with the terminated contractor for default. And the issue was whether it hinged, the notice that was provided, whether it hinged on strict or only substantial compliance with a written notice condition precedent to such recovery. And if substantial compliance with the notice condition was all that was necessary, it's whether there was legally sufficient evidence that supported the jury's finding that there was compliance with the notice contract. However, or the notice part of the contract. However, if 2 of the 3 required notices were not given in writing, could there be substantial compliance? So let's get into some of these facts here. So what is this case? So really the contract required all notices to be provided in writing. This is a very common clause. We see this all the time. But then when it gets to the T4D, there were 3 specific notices that needed to be provided by the owner for entitlement to the damages underneath this clause. So first, the owner had to notify the contractor that in its reasonable opinion, the contractor had serious safety violations. And if the contractor was so notified, it had a 72-hour window to remediate these safety violations. The second notice was if the owner was not reasonably satisfied with these remediation efforts, the owner again had to notify the contractor. Lastly, the owner's, at the owner's sole discretion, the owner was required to provide a third notice if it wanted to terminate the contractor. So 3 notices in order to grant entitlement under this T4D clause. So as is often the case, when it comes to schedule-related claims, there's a written notice requirement for schedule impacts, and often there's an express condition precedent to the contractor's right to time extensions and schedule-related claims associated with this notice. So what is, or how did this case play out? So the owner was able to point to 3 notices that it said satisfied its obligations under the T4D clause. The first notice was an email. However, the court questioned this specific email as to whether it was even sufficiently qualified as a notice under the T4D clause. The owner failed to identify the specific clause it was relying on. The owner failed to identify anything regarding default, the commencement of the 72-hour window, or even a warning that there was a potential termination for default if the contractor did not remedy its safety concerns. The second notice that the owner pointed to, the court was very clear that this one did not qualify as a sufficient notice. The owner was express in its email to the contractor that no decision had yet been made. So it told the contractor that this notice was not one of the notices under the T4D clause, later to rely on it in litigation. And lastly, it was undisputed that the owner did not provide a notice of termination to the contractor. However, the contractor did have actual notice that it was terminated. It stopped work, removed its equipment, everybody moved on. However, even though the contractor had actual notice, that was not sufficient to satisfy the written notice requirements from the T4D clause. So as the result of this, the owner failed to provide the written notices and therefore was not entitled to the expenses associated with the T4D clause. And the Supreme Court of Texas was very clear and held that substantial compliance is the standard when evaluating whether a party complied with a contractual notice condition. However, substantial compliance with a condition precedent requiring written notice requires a writing in some form. So again, going back to the contractor having actual notice that it was terminated and stopping work, that was not a substitute for the required written notice. So we have some key takeaways here. Obviously, again, this is a substantial compliance state or substantial compliance issue. However, there's more than that. Look to the conditions precedent, look to the necessity of a written form in some fashion. Actual and oral notice is not sufficient, does not satisfy a written notice requirement. So what do? When we ghostwrite some of these notice provisions and we provide counsel, what we like to do is quote the specific contractual language. In the specific case, James v. Westlake, the court went into great detail regarding the contents of these alleged or intended to be notices. And the court identified specifically that the clause was not referenced, that default was not referenced, and the results of what was supposed to come out of this notice was not referenced. So these are all things to consider when you're providing your notice, is what do you expect to happen and what are you relying on? And then 5 and 6 taken together is put everything down in writing. You'll have meetings, there's a lot of communication on the project, a lot of it is in person, and when anything important comes up, particularly notice provisions, but even other provisions, it's important to have follow-up communications and put everything down in writing contemporaneously. Let's move on.
Yeah, Brad, real quick, just before you move on, I mean, I'll add, the case obviously dealt with a termination for default, but we see these, what I'll call cascading series of notice requirements in all parts of contracts. I mean, we've certainly seen them within areas where you are supposed to notify an owner of delay events. So although the case addresses termination for default, the lessons learned, I think, can certainly be broadly applied, particularly within the scheduling context as well.
Yeah, that's entirely the takeaway there is good project yes, sir.
Yeah. What's the best method of communication? So we have emails, you have letters, but if it's a letter via email, you have distribution issues. Should you follow a specific, if you have a document control system, is there a best practice, or what would you recommend?
I prefer the concept where you have the email that has a written form letter that identifies all the facts that we're dealing on, the subject matter, the date, the people that it should be going to, and then this email can be distributed to anybody you really want to bring in. So then you tie it directly to the certain parties that are giving this coordination or not. So that's my preference and what I see.
Yeah, and
it's helpful.
And I would say start with the contract too. Obviously do whatever it says. But moving beyond that, I mean, you can never over notice something, frankly, but do what the contract says, and then emails, letters, if you want to mail and follow up an email, all of that's great.
I just know during the discovery process, what's the best, what carries the most weight, I guess, is what I'm looking for.
Whatever complies with the contract, no doubt about that.
Sure.
But then beyond that, I wouldn't necessarily say it's the vehicle of the notice, but the contents itself that carry the most weight. So, whether it's an email or a letter, make sure you get what you need to get into it.
Yeah, and I don't want to read your mind or anything, but I do think that I see where you're going with this, and that I'd like to have, and that's why I said the letter attached to the email, so you can separate this bucket of communications, and so you can give this to your project team, you can give this to your attorneys and say, here are what we believe are all the notice provisions. If there's anything that's lacking, that's when we would go and search through emails and other project correspondence. So on this issue of notice, there's also the issue of timeliness. And there's a specific statute in Texas that's actually been around since 1891, and I'll get to this here, regarding the time frame to provide notice of a claim for damages. And so here, 16071 is a requirement that if a contract provides a notice of a claim for damages as a condition precedent on the right to sue on the contract, it's not valid if the stipulation is not reasonable. Anything less than 90 days is just inherently void. So what does this mean in the construction contract context? Well, I've got two examples here. First, there's the Consensus Docs 200, Standard Agreement and General Conditions. This requires the written notice of a claim within 14 days after event giving rise to the claim. The AIA 201, General Conditions, requires notice within 21 days. So how do these claim notice provisions in standard form construction contracts comport with this Texas statute? Well, there's a case on point here, El Paso City. In this case, there was a 7-day notice provision, so even shorter than the 14-day claim notice and the 21-day claim notice. The contractor argued that the statute I showed you previously, 16071A, applied to this contract because it effectively barred the contractor's right to sue for damages for additional compensation and additional time. However, the owner took the opposite side, obviously, and said that interpreting 1607 required that a claim for additional compensation or additional time, as drafted in this claim notice, which I'll show you in a second, is not a claim for damages under the statute. So what is this notice provision that was subject to the 16071 statute? Hold on one second. Excuse me. All right, great. So the trial court looked at this provision, read it in light of 16071, and found this to be subject to the statute and void as a matter of law, and granted partial motion for summary judgment to the contractor. But the Court of Appeals reversed, finding that the contractual notice provisions do not fall within 16071A when they require notice of a happening of some event that is antecedent to the accrual of a cause of action and from which a cause of action may not arise. So that's a lot there, so let's unpack that. So there's a clear distinction between notice of a claim for damages and notice of an event happening. Under the terms of this specific construction contract, the submission of a notice of a claim for additional time was only a precursor to a possible cause of action for damages, which may or may not result. The 7-day claim notice deadline did not mention a claim for damages, just an event happening, and the construction contract does not contain such a provision. So there wasn't a separate claims provision that required you to bring your damages claim within a certain time frame. So this was the clause at issue and the only one available. The parties had a specific continue to work provision that required the contractor and the owner to fulfill their obligations while claims were submitted. And then after submission, the contract contemplates the owner will investigate the claim, and in the event of identified schedule impacts, the contract schedule will be adjusted. So this is what William was referring to earlier. The contract has certain mechanisms for handling claims. It's an issue of fundamental fairness, and really some of the cases here don't say that expressly, but the case law on notice provisions goes well into this concept of fundamental fairness. And everybody expects that the contract will be modified, or that's the intended purpose, when properly noticed and properly documented and properly supported. And that's the mechanism for all your changes. So anyways, to finish this out, the notice provision at issue addressed in this specific contract, the events that could lead to a claim for damages did not constitute a notice requirement encompassed by section 16071A because they were not stipulations requiring notice of a claim for damages as a condition precedent on the right to sue. So it's very specific and strictly interpreted, this section 16071A. But this case does not stand alone. There's also the Port of Houston v. Zachary. And I believe anybody in Texas is familiar with this series of cases. I don't want to get into too many of the specific facts on this, but this one narrow issue regarding this notice provision time frame and 16071A and its applicability is important here. So the contractor claimed a breach of contract by the owner because the owner rejected the contractor's means and methods after executing a change order. So the contractor's position was that this was a breach. It had nothing to do with the notice provision regarding claims or changes. So the changes provision here required a 5 days written notice for any interpretation of the contract that believed constituted a change. Now, the owner would have the parties read this notice provision to be a 5 days notice for any breach of the contract. But this reading would be void under 16071. Interpreting the changes clause as the owner proposed would convert nearly any breach of the contract by the owner into a change, subject to the chief engineer's final approval, determination of whether the owner properly interpreted the contract, so on and so forth, the whole changes provision. So the court ended up finding that this notice provision was inapplicable under the circumstances of this case, as it applied only to changes and not to breaches of the contract. So pulling these two cases together in the statute, when you look at your claims provision, you need to consider the scope and differentiate the difference between what is a claim, notice of an event happening, or however claim is defined, versus notice of a breach for damages. And these short notice provisions that you see in some of these contracts, whether it's the standard AIA or consensus docs, so 14 for consensus docs, 21 days for AIA, 7 days for El Paso, 5 days for Port of Houston, these are all enforceable under Texas law, and they're not invalidated by 16071. And lastly, a typical notice of a claim provision, again, is a notice of an event occurring that may or may not give rise to a claim for damages.
Yeah, and Brad, real quick before you move on to your next one, I'll just add too that a lot of times we see people in somewhat of a panic knowing that they've missed what appears to be a contractual notice deadline. But I think this is a good example of certain unique circumstances when you may have in fact not missed that deadline. So don't always give up hope, just call one of us.
And speaking of somebody getting into a panic, in this case it seems that the contractor did get into a panic. So what is the distinction between notice provisions regarding schedule delay, extension of schedules, versus provisions regarding acceleration of times, impacts, not changing the schedule, contractor adjusting to things that happened during the project but still meeting its schedule? So this is the MMR Dow case. It's fairly recent. It's a 2020 decision. The parties had a fixed price contract, about $40 million. You can see $40 million as compared to the ultimate $17 million claim for acceleration. The work was to be done in about a year time frame. The contractor appeared to meet this time frame, maybe off by a week. But during this time period, executed 12 contract modifications, change orders that included broad waiver and release language. And then, excuse me. Yep. So the contractor executed 12 contract modifications with the owner, and then after the project was mechanically complete, submitted its initial notification for acceleration costs. So on its face was clear this is the first time the contractor was providing this information to the owner. And the contractor provided this claim under Article 15 of the changes clause. But then a month later backed away from that and said, no, this is not under 15, this is under a different clause. Well, jumping all over that, the owner had two defenses. One, the broad waiver and release language of these change orders is referenced. There was 12 of them, all before the initial notification of acceleration costs. And two, failure to comply with Article 15 and Article 18. Article 15 is the changes clause. Article 18 is the claims clause. So what are these changes and claims clause? So the changes clause at issue, you can see it's fairly standard for the most part, 5 working days notice regarding impacts to the schedule or costs. Contractor must notify the company, and if the contractor fails to provide the requisite notice, it will have no entitlement to any compensation or change in the schedule. This 5-day requirement is restated in the claims provision, where if the contractor fails to provide the owner notice of an event requiring a change to the schedule or compensation, the contractor would waive these potential claims that were not reported. So obviously, the contractor did not comply with this. Initial notification was provided after mechanical completion, so they wanted to rely on something else. Was there another provision hanging out there that could help them out? The answer is yes. They had a specifically negotiated provision for the impacts that the contractor was expecting or anticipating. And you can see they even had this red language in there. In italics, it is intended for all of the contractors that were out in this project that could impact this specific contractor's work on site. So the contractor argued that Section 10.2 required mandatory compensation for acceleration costs. Section 10.2 also did not include a process for submitting these claims, and you can see no reference to Article 15 and Article 18. So the contractor intended to rely on Section 10.2 solely to get around 15 and 18, the notice provisions. It was specifically negotiated, as we said. And one point that is interesting that ultimately didn't pan out for the contractor was the concept that where this Section 10.2 was in relation to Article 15 and 18. It was in the special terms and conditions. those actually prevailed in the order of precedence over the general terms. Ultimately, that wasn't a successful argument, but that was an interesting point. So why did the contractor have to argue under 10.2? Well, the point is that these broad waivers of release were very broad. It covered all releases of claims, except those previously noted, and it even included the reference to additional compensation arising out of delays or disruption, in other words, acceleration costs. But here, the contractor's argument was similar to this Port of Houston-Zachary concept, where there is a distinction between notice of a claim versus a claim for breach. And so the contractor argued that it was bringing a breach claim, not a claim for additional compensation or time or acceleration costs. However, ultimately, the court agreed with the owner on two parts. First, that the release was not limited to notices under 18 and 15, that it was for all notices. And second, for all claims, not just those that were noticed under 15 and 18. And second, the broad waiver and release specifically identified the delays and disruption costs, and therefore the waiver was held enforceable. All right. So what are the takeaways from this one? If Section 10.2 was specifically negotiated by the contractor and intended to not fall subject to 15 and 18, you got to tie off that provision, make sure that everything works together as you intended and as you specifically negotiated. Second, claim is not a four-letter word. They're an integral part of the contracting process. They're the mechanism for adjustments to the contract price and contract schedule, fully expected by sophisticated owners. And failure to comply, as shown here in this case, can prove catastrophic. And lastly, there's always the opportunity to negotiate during the project any type of reservation of rights, but you only get there by bringing up the actual claim at issue and notifying the parties so that the discussion can be had contemporaneously versus losing your rights based on the claim provision. That's it. William?
Thanks, Brad. And just to put a bow on that last case, there was an interesting nuance there when you had two general conditions terms talking about notice, but then that later section 10.2 that came out of special terms, which under the contract overrode the general terms and conditions. And so you saw, I think in some respect, conflicting notice provisions. And so, like I said previously, don't give up hope. There is a lot of nuance and complexity to many construction contracts. And so what may be stated in one section very well could be overridden in another section, particularly with some creative lawyering. Moving into our second main topic, I want to talk just a little bit about causation issues in schedule analysis. And this is something that we frequently see. Like I mentioned at the beginning, that someone will show up and say, there have been these delayed events, and therefore I'm owed these delayed days. But what quite often is the case is that there is a lacking causal connection between those events and those delay days. So taking our cartoon, for example, we assume that the construction is delayed because everybody is consuming the construction materials. But for all we know, there's a big stack of gingerbread just off to the side, and the project hasn't in fact been delayed at all. Yet we are left with the assumption that everyone eating what they're supposed to be using to build with has delayed the project. There is a shocking, I think, lack of good case law that guides this issue. That gives us a bright line rule about, okay, here is what we have to see, we need to see, we want to see with this issue. That I think, frankly, you don't often see in other hotly litigated issues. Taking all the tobacco litigation, for example. There's a lot of law about what you have to show that cigarettes caused your cancer. There's not a lot of law about what you have to show that these events on the project caused your delay days. And I think in many respects that leads to this concept of the dark art of delay analysis. I think quite frequently people think that, well, we've had this delay, I will call in a forensic expert, they'll sprinkle their magic fairy dust over everything, and then we'll get our extension. Or we'll go litigate it or we'll go litigate about it in federal court. But we're always looking for guidance. We're always looking for something that we can hang our hat on to ensure that we don't have happen to us what happened in this next case that I'm about to discuss. Before I get into this case, though, I will say you will see the court is extremely critical of a forensic delay expert. I'm certainly not here to rail on that expert. I'm certainly not here to rail on that expert's client. I know nothing about the underlying circumstances. All we know is what the judge saw in the schedule analysis. And so that's what I want to focus on. But this is the Balfour Beatty rail case. It's a little bit older, but I still think recent enough to provide some guidance, and it's certainly useful given the overall lack of very firm, bright line guidance that we've gotten, particularly in Texas, on causation analysis within schedule delays. And so what the court was looking at is what level of analysis is sufficient to tie delay events to critical path delays. And so just to quickly set the stage, the contractor was delayed by events supposedly outside of its control. And it, again, oversimplifying things, it primarily related to the delivery of ballast for use in construction of a railroad. Contractor sued. This is the Northern District of Texas, so they're in federal court. And the contractor showed up with their forensic scheduling delay expert who identified, among a whole host of other things, 28 days of compensable critical path delays. The court, as we will see in a second, did not buy any of it. And so like I said before, this isn't necessarily a shining example of what to do. It is in fact a shining example of what not to do when you're trying to bridge that critical causation gap. But again, because we have somewhat of a lack of good case law, sometimes we're left with examples of what not to do to guide our future actions. And so I've pulled a couple excerpts out of the judge's opinion, and it was a very long opinion issued by the court with a section dedicated solely and exclusively to talking about how much the judge disliked this causation delay analysis. And what the judge said here in this example is the expert proceeded to testify whether certain events constituted critical path activities with little or no explanation other than to say that he reviewed certain documents, the schedules, and project activities. And that's something we see fairly frequently in a lot of expert reports that we receive on projects that we work on. We will see a parade of horribles and then just a generic statement or a general statement, and there were these delays. But what the judge was looking for here was, I think, reading the tea leaves, a detailed or at least a rational explanation about these critical path activities that was actually tied to documents within the project record, rather than, as we'll see in a second, more of these broad-based assumptions that just so happen to support his client's position. So the judge went on to say that the expert acknowledged that in drafting his expert reports and opinions, he did not previously consider a key document in the case. That included dates, the railroad delivered ballast at the project site, and Balfour Beatty's crews unloaded ballast trains. And so, again, oversimplifying things, there was a key project document that outlined all of the dates that ballast was delivered to the project site. And as far as I can tell from the opinion, it was largely undisputed. Nobody said it was inaccurate. The contents of that document just didn't really support the expert's forensic delay analysis, so he ignored it. And this wasn't like he overlooked a minor project record, which happens particularly in larger cases where you have millions of documents in ESI. This was a document that was very much a centerpiece of the trial and the claims. But the judge said, look, you did not take this into account. So how can I trust your causal analysis when it doesn't seem to be premised upon key and important project documents? And when we get to the end of this, I'll kind of tie off some key takeaways, but I'm going to move through the judge's language here first. And so continuing on, the judge said, the expert's conclusion is not supported by Balfour Beatty's daily reports and instead has built into it an assumption based on vague and incomplete information in Balfour Beatty's daily report. So again, the forensic expert was relying on what the judge valued as vague and incomplete information within his client's own documents. So again, you see the expert trying to tie that causal connection together, but the judge saying there isn't enough underlying information to tie these events together. And instead, what you're doing is just making broad-based assumptions, assumptions that really cannot be made in court and cannot stand up to scrutiny. And I won't read all of this because as Tiffany noted, I think all of y'all will have these materials in your packet when you leave today. But I'll focus on the second paragraph here. And the judge said, he, the expert, simply assumed that Kansas City was required to deliver any quantity of ballast in any time frame demanded by Balfour Beatty. Experts' reliance on this unsupported assumption is fatal to his opinion that Balfour Beatty's work was delayed because of insufficient ballast deliveries by Kansas City Railroad. And so, again, oversimplifying things, the expert said, look, Balfour Beatty wouldn't have been delayed if Kansas City had just sped up and increased its ballast deliveries to the site. The problem with that was that the contract did not require Kansas City to do that. And so if you're going to claim that if someone did X, then I wouldn't have been delayed, well, you better make sure that other person actually has to do X. You can't just summarily state, well, if they had done this, we wouldn't have been delayed, so give me my money, give me my delay days. And as the judge said, this assumption is fatal. And I think perhaps this is what the judge focused the most on. The fact that the expert in many ways invented a contractual obligation to, again, try to bridge that causal analysis that ultimately was lacking in his opinions. And just to put a bow on everything, the judge concluded this section by saying the expert's testimony is unreliable because his opinions were based on erroneous assumptions and inaccurate data. Overall, the court found expert's testimony and his opinions to be overly simplistic, subjective, conclusory, and unhelpful. Nobody ever wants to see that written in a published federal court opinion. And again, like I said, I am not here to rail on the expert or the client. The judge took care of all of that. So, but there it is. I mean, it is there in black and white. And so the judge didn't say, this is what I want. The judge just said, this is definitely not what I want. And so what do we draw from that? Well, I think one, causation is king, obviously. You have to be able to tie those delay events to your delay days. To do that, though, I think your analysis must be grounded in the project record, because we saw the judge going back to that over and over again. You're basing your opinions on vague documents that don't necessarily support what you're saying. You're ignoring other key documents that, in fact, appear to directly refute what you're saying. So focus on the project record, ground your analysis in the project record, and use that to try to bridge the gap. And in line with that, document. I mean, always document your project. That's a kind of a construction 101 takeaway, but I think it's worth noting here again because I think the expert was somewhat hamstrung by the fact that his own client didn't necessarily have the best project record for him to rely upon. And that's not the expert's fault. The expert can only work with what's placed in front of him in many regards. And so make sure you're documenting your project the way you should be. Avoid assumptions. That was something the judge returned to over and over again. You're just making assumptions. But I will also caveat that by saying, look, I get it. In the real world, sometimes we have to draw assumptions from what's in front of us. So that's not to say don't ever do it, but that's to say if you're going to do it, it better be grounded in a good project record and you better have a good basis for it. Because otherwise the judge is going to whole-handedly dismiss that. And finally, as I've talked about before, there's no bright line rule. If anything, some of the best guidance we have is what not to do. And so just to kind of wrap up this case, I will say that yes, this was within a federal court context with a forensic scheduling expert testifying before a judge, but I think these lessons can be applied at any point in a project. If you're drafting a notice to an owner of delays, do what you can in that moment to connect those dots on your own. And if you do a good job of that, you won't need to pay a forensic expert to get hammered by a federal judge later. So try to do that in real time. And from an owner's perspective, demand that in real time from your contractors. Always be looking to bridge the gap in causation from delay events to delay days. And I think that will pay dividends from a contractor perspective, but also from an owner perspective as well. Any questions before we move on to the last part?
What was the client trying to avoid? LDs, cover costs?
They were trying to recover their delay costs.
Okay.
So they were trying to get a schedule extension as well as, I believe, the daily damages associated with those project extensions. So, good, we're doing great on time. Rolling into our last section here before we kind of wrap up for the day. There's a new case that came out kind of recently about liquidated damages that addresses some interesting nuances. And so To set the stage for that case, I won't go through all of the basic elements for what makes a liquidated damage clause enforceable, but I will focus on the two components that were at issue in this case. And so the whole point of liquidated damages is to try to establish an acceptable measure of damages that the parties stipulate in their contract. And it's generally within the context, or always should be within the context, of a situation in which your future damages may be hard to calculate or estimate. But for purposes of our case, what we're going to focus on are two components of liquidated damages in Texas. And that's one, harm caused by breach is incapable or difficult of estimation. So you need to show that to have an enforceable LD clause. And the amount of LDs is a reasonable forecast of just compensation. So if you're going to try to seek LDs, at least within the context that we're about to review, you have the burden to meet points 1 and 2 there. And 2, I will also note that 1 and 2 are viewed within the time frame of when the agreement is signed, not with the benefit of hindsight. And we'll see why that's important here in just a second. And then I stuck in here just a standard consensus docs LD clause, just so you have that. You'll have that in your materials that you take away from here today. But what I want to focus on is the Atrium Medical case from 2020. And essentially the court was looking at, okay, when you're forecasting future damages, what is a reasonable estimation of that and when is it enforceable? Long story short, Atrium Medical dealt with a requirements contract for linen services at an acute care hospital. And so House Red entered into a, I believe, 5 or 6 year requirements contract with Atrium Medical to deliver linens to their hospital. One of the issues they had is it wasn't a set amount of linens every month. The hospital wasn't sure exactly how much they would need, and so they said, look, we'll probably order between X and Y amount, and you agree to fulfill that on a monthly basis. House Red said to themselves when they were negotiating the contract, okay, great, but if you terminate this contract early, that's going to hurt me because I'm putting a lot of investment and a lot of ramp up into preparing for this 5-year requirements contract. I need some protections. And so what they did is they put an LD clause in there that had a somewhat complicated formula for calculating LDs. And what they said is if you cancel this contract early, Atrium Medical, you'll pay us LDs 40% of the greater of the initial agreement value or the current weekly invoice amount multiplied by the number of weeks remaining in the contract term. And we'll see why that's important in a second. But long story short, everybody agreed to that clause, everybody signed that clause, and it was supposed to be and intended to be a reasonable estimation of House Red's damages if Atrium Medical canceled their requirements contract. So the court looked at this a couple different ways. Well, taking a step back. As soon as House Red started performing on the contract, Atrium Medical found itself in a crisis when its managing director was embezzling funds. So Atrium Medical had no money to pay House Red within 3 months of the contract beginning. And House Red continued to supply linens for a few more months after that, but they said, if you don't pay me, we're going to stop. And so the person appointed to watch out over Atrium Medical as their former director was under prosecution said, fine, we'll just cancel the contract. The liquidated damages using that formula coming out of that on the remaining 4.5 years of the contract were about $2 million, give or take. Atrium Medical fought back against that and said, no, this isn't an enforceable LD provision. And so it made its way up to the Texas courts. And so when reviewing this LD provision, the court started with one, were the damages difficult to estimate at the time of contracting? I think yes. It was a requirements contract, and the parties themselves acknowledged that they weren't totally sure what the month-to-month requirements would look like. And in fact, they expressly contemplated some level of variance within those invoices. So when they signed the contract, yes, it seemed reasonable. What happened during performance, though, is that the monthly invoices were almost all exactly the same every month. And so what Atrium Medical said is, we don't need these LDs. We know exactly what your damages are looking forward in the future because each monthly invoice was almost exactly the same, so it's very easy to calculate your actual damages. Well, the court said, that's fine, but we're looking at what everybody thought at the time you signed the contract. And when you signed the contract, no one knew that was going to be the case. And so what we are going to do is say, were these damages difficult to estimate when you signed the contract? Yes, good. You've met point 1 of your requirement. So the court moved to point 2, and they said, was this a reasonable forecast of just compensation? Well, there was testimony in the record from one of House Red's, I believe it was his chief financial officer, who said, look, I came up with the 40% number because of reasons and factors X, Y, Z. It was generally related to their expected profit and revenue off of similar contracts. And the court said, yeah, I mean, that seems reasonable to me. And Atrium Medical didn't really have a basis to rebut that other than to say, well, it can't be reasonable because the actual LDs they're getting are more than the actual damages they've suffered, and we know those damages, they're actual damages because of the same invoices. But again, the court said, I think it's good enough. And in fact, the court said the parties are expected to negotiate a reasonable, not perfect forecast of just compensation. And so I think that's a critical takeaway from this. The court, in reviewing an LD provision, whether it's for delay or cancellation or anything else, isn't necessarily going to say, okay, has hindsight proven this to be the best possible effort it could have been? They're going to say, were the parties doing the best they could under the circumstances given some of these factors we've looked at? And that's what the court did here. The court said, yeah, no, you meet the standards. This is reasonable. Based on the testimony of your CFO, and I agree that when you signed this contract, these damages were difficult to quantify. And so the court enforced the LD provision, and House Red walked away in that regard a winner. I'll touch briefly, just because we have time, on 2 minor issues that also were addressed in an ancillary nature in the case that I think are good just to keep in mind for LD provisions. One, LDs are not enforceable when trivial breaches of the contract are treated the same as important breaches. So if you're going to assess LDs for every day a contractor doesn't submit their daily report, a court might say that's a trivial breach and you don't have to pay someone $1 million a day for that. But if you're going to assess LDs every day after substantial completion that the contractor's late, that's a different matter. So that's one thing to keep in mind when you're assessing an LD clause in your contract. And then 2, and this is a bit more wishy-washy, but LDs are unenforceable if an unbridgeable discrepancy exists between the LDs as written and what would actually be applied. And so the court looked at this unbridgeable discrepancy concept within the context of House Red's actual damages versus their LD damages. And possibly, if the court had discovered that House Red's actual damages were only $100, but the LDs were going to pay him $2 million, they might have said, wait a second, there is an unbridgeable discrepancy here. And because of that, I am not inclined to enforce this liquidated damages provision. But again, the court just addressed this as a glancing blow, almost. They didn't go into deep detail, and so I leave that there more for contemplation and as an intellectual concept than something that necessarily you can address in your contract itself, because really it is more of a hindsight analysis. But as with some notice provisions, there is a possible release valve there if you are facing an assessment of LDs. So to wrap this all up, some things to consider when you're drafting LDs. You want to have a good contemporaneous liquidated damages calculation. You want to put some thought into it. And with that in mind, I would highly recommend don't just use liquidated damage amounts from other contracts. And when we see that happen the most is a form contract, whether it's a consensus doc contract that we just looked at, where you have the form in there and you just kind of keep it the same over and over again and you recycle it. Because that creates the risk that you haven't put the necessary thought into it at the beginning to say, okay, I'm trying to create a reasonable forecast for what my admittedly difficult to estimate damages will be. So always be thinking about that with your LD provisions. Be thinking about major versus minor breaches. We talked about that a second ago, but you don't want to be seen as overly punitive or vindictive for minor breaches, and don't use LDs as a weapon in that context. I put a couple other little brain teasers in here just to contemplate. What if your project, for example, an EPC contract does not achieve its performance requirements? So it's delayed, or excuse me, it's not delayed, so there's no LDs for delay, but it's not performing as it's supposed to. Now, how do you want to structure LDs in complex contracts and situations like that? Do you have an LD cap? And what I saw once in a contract is that someone had an LD cap, and then beyond that cap, you could claim actual damages. And the enforceability of that provision was never put at issue, but no one ever actually tried to say you can't do that. So what the contract said is, okay, for the first 5 weeks you're delayed, you incur LDs at this amount up to this amount. Once you reach that amount, every day after that, I can claim actual damages. Now, there seems to be some inherent tension within that because the LDs are supposed to be for damages that are difficult to contemplate. And in theory, you're not supposed to have your cake and eat it too. It's supposed to be a sole and exclusive remedy, but people can get creative with contracts. So that's one thing to think about as well. And I put the sole and exclusive remedy in there. What about LDs for a termination for default? What about actual damages and consequential damages if your LDs are unenforceable? And finally, what about partial occupancy? And I put these things in there not because there's an exact or correct answer to this, but because there are many, many different types of things that you really need to think about in crafting a good and enforceable LDs provision. So don't fall into the trap of just putting a number in there, calling it a day, and moving on. And with that, Brad, we have finished 120 seconds ahead of schedule. Questions?